Now, judges, I'll let you introduce yourselves. Thank you.
There we go. Yep, I got it that time. I'm getting better. Hello, everybody. My name is Thomas Mackey. I'm in the history department at the University of Louisville and with the Brandeis School of Law here at the University of Louisville. Rita?
I'm Rita McCannon. I'm an attorney in Huntsville, Alabama, and I'm really glad to see all you guys today.
Hi, I'm Jay Barth. I'm the Chief Education Officer for the City of Little Rock, and I'm a emeritus professor in American politics from Hendrix College, and great to see y'all.
Yeah. Why don't you guys introduce yourself and tell me where you're from?
Hello, I'm Gianna Tantillo, and I'm from Long Island, New York.
Hi, I'm Jessie Boxenhorn. I'm also from Long Island, New York.
Morning, my name is Wahab Ahmed, and I'm also from Long Island, New York.
Hi, my name is Kayla Renard. I'm also from Long Island, New York. We're Unit 6, and our teacher is Mr. Pittman.
Unit 3?
Unit 3.
I don't know
Yeah.
why I said 6. Sorry.
Okay, no problem. As long as we're on Unit 3. We're going to ask question number 1. Question 1 reads as follows. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin.
A constitution is and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning. Alexander Hamilton, Federalist 78. Because judicial review, established in 1803 by Marbury v. Madison, gives the federal Supreme Court the power to overrule state laws and aspects of state constitutions by declaring them unconstitutional, the practice is fundamentally intertwined with the concept of federalism.
Federalism acts as a multifaceted governmental system in which the central government and municipal governments are balanced. As described by Alexander Hamilton, this balance between the national and state governments ought to be dwelt on with peculiar attention, as it is of the utmost importance. It forms a double security to the people. If one encroaches on their rights, they will find a powerful protection in the other. Indeed, they will both be prevented from overpassing their constitutional limits by a certain rivalship, which will forever subsist between them. Though powers are carefully divided between the state and federal governments, judicial review inherently shifts the balance of federalism towards the national government.
Modern judicial review poses a unique threat to federalism because it enables the Supreme Court to preempt state law and impose nationwide policies by a simple majority vote and without the consideration of any other institution. While the original purpose of judicial review was to allow the Supreme Court to translate and interpret the Constitution, modern judicial interpretation of the Constitution originates in court-created doctrines and precedents rather than in constitutional language.
As stated by Oliver Wendell Holmes in his speech at Harvard Law School, it is misfortune if a judge reads his conscious or unconscious sympathy with one side or the other prematurely into the law and forgets that what seems to him to be the first principles are believed by half his fellow man to be wrong. Because the Supreme Court can create nationwide policies and overrule state decisions with a majority vote, this may oppose the interest of the people. This expresses the capabilities of judicial review to alter the balance of federalism, as a federal government branch has the power to disrupt state laws and constitutions, possibly against the desires and well-being of the state.
The interest of the people is the foundation of democracy, in that the majority has the say to overrulings and ongoings of government and society. That being said, judicial review, despite being an arguably necessary and beneficial practice, can be considered a counter-majoritarian practice. The counter-majoritarian difficulty is somewhat characterized as a problem with the institution of judicial review, but it could also be understood as a difficulty for any constitution that constrains majority will. Alexander Bickel.
The decisions of Supreme Court often do not represent the will and desires of the majority of Americans. While these decisions do represent an educated and current interpretation of the Constitution, the accuracy to which they represent the opinions of the majority of Americans can be determined by the specific judges that currently sit as Supreme Court justices, and more often than not is not representative of the majority opinion.
One example can be viewed in the case of Brown v. the Board of Education in 1954, in which the Supreme Court ruled that the previous court ruling of separate but equal was unconstitutional and that segregation was not allowed in schools. The decision in this case went against the majority opinion in many southern states, but was necessary to ensure progress. While it can be argued that judicial review is a counter-majoritarian process, its continued implementation is necessary.
Because of the controversial nature of judicial review, it is often argued that certain limits should be placed upon the power to ensure the protection of rights. One limit that could be placed on judicial review is requiring a supermajority vote among the Supreme Court justices for a ruling, rather than the simple majority that is currently necessary. This limit would ensure that the Supreme Court decisions regarding judicial review could not simply be acting in favor of one political party's agenda. Instead, it would require bipartisan support to pass a ruling of judicial review and to declare a law unconstitutional and void.
You're good?
We are now ready for follow-up.
Oh, cool. Okay. Interesting. Surveying the waterfront here of this issue of judicial review, interaction with federalism. At one point in your presentation, you talked about court-created doctrines as contrary to the will of political majorities. And I assumed political majorities in Congress at the federal level or in the states. Could I push you a little bit to ask you what's more specific about which specifically court-created doctrines you had in mind with that phrase?
Well, just to open up the answers for your question, not necessarily all court-created doctrines go against the will of the majority of people, but because of the nature of a doctrine in that it comes when a judge would make a ruling and the process is like outlined and applied, it could occur in which this doctrine would go against the majority will of the people, but not necessarily always would.
Yeah, and I was trying to, I drive my students crazy, don't worry. My two favorite words are be specific. So I was looking for you to be a little more specific about court-created doctrines. What did you have in mind with those? Ms. Boxhorn, I think that you wanted in, I could see. I'm sorry, I've cut you off.
Oh, no, I didn't, but I'd first like to address judicial review in general and how that was created in 1803 in Marbury v. Madison, and it declared that Supreme Courts have the right to declare executive and legislative cases unconstitutional. And so in regards to the court case doctrines, I think Wahab has some intel on that.
Yeah, so I would like to expand on what Alexander Bickel has stated in the past with the counter-majoritarian difficulty in 1962. And that expands on his interpretation of Article 3 of the Constitution and how that implements a counter-majoritarian interpretation and implementation. And so with the Supreme Court being an elite group, there are Harvard Harvard professors, and they received elite education. They do not represent the majority of the people who have not received that education, and they have not looked into that perspective of the common people. But I would like to argue that this actually has worked in the past. So I believe that counter-majoritarian implementation would actually be beneficial in their interpretation.
Just to close out what my colleagues are saying and give you guys specific examples of court cases that aren't exactly supported by the majority, cases like Brown versus the Board of Education and Heart of the Atlanta Motel versus the United States, sorry about that, were both cases that dealt with civil rights, and they weren't well received in the areas that they were brought up in. They were brought up in the South. And either way, those cases need to be made. We needed to rule in favor of civil rights in order to move forward as a nation.
Rita, you went in?
I'm not sure, they're over my head already. I want to change gears just a tiny bit and see what you guys think. Senator Ted Cruz wrote a book called One Vote Away, claiming that a single Supreme Court seat can change history. We've had a lot of discussion about that the last few years in our current affairs. But what do you think he meant by that? Do you agree? And explain that.
I entirely agree with that statement in that one single court case can definitely change the making of history. Everyone has their own interpretation of the Constitution, whether it's a loose or strict interpretation, and that leads to different biases. And as a result, if you're a more conservative judge or a more liberal judge, your viewpoints will be shifted in one way or the other, changing the actual framework of our government. So, for example, for the legalization of like marijuana, if you're more liberal or you're tended to more go for the legalization. However, if you're more conservative, you would necessarily not want that. And so, depending on who's there and who's a part of the Supreme Court, those decisions are made by your views, and everyone has different views and biases.
And just to follow up on what my colleague said, I do believe the book in question was discussing how one Supreme Court seat could change history rather than one case. So that could be seen even in recent history with the replacement of the late Ruth Bader Ginsburg. Because Ruth Bader Ginsburg tended to be more liberal in her beliefs and would vote towards more progressive votes on decisions that were brought to the Supreme Court rather than her replacement, who tends to be more conservative and relies on a more stricter interpretation of the Constitution. So going forward, looking at different things that might come to the Supreme Court, such as Second Amendment rights or rights on women's rights, those decisions might come out differently now that there is another more conservative and more strict interpretation leaning judge on the court rather than who she was replacing.
I'd like to add on to what my colleague Gianna has stated and look at the structural changes in the Supreme Court if this were to happen. So I would like to mention the rule of four, where four justices can grant a writ of certiorari, which would limit judicial review. And so adding another Supreme Court justice to this would inflate that number, and it could alter the balance that we currently have right now.
So if there is so much power in a single appointment, would we be better off if we had term limits on justices? And if you could just lay out kind of the arguments for and against, and then where you come down on that issue.
Personally, I believe that we should not have term limits for Supreme Court justices. I think that in that way, we would also have to have re-elected judges. We would have to have elections, and that would sway the decision away from what the judge thinks is right and more towards the party that the judge is working with. I don't think it's fair to have the people who are interpreting our Constitution and, debating our laws to be working for either side of any political agenda.
And just to present the other side of the argument that judges should have term limits, there is an argument that much like most elected officials, if you do need to be reelected, such as a judge would, then you would be more focused on making sure your opinion came down with the majority of the people who support you and the people who would be voting for you, which in this case would be the citizens of the country. And so in that regard, judges having term limits can look like a very beneficial aspect, especially when you consider the timing of, we don't know when a judge seat might open up on the Supreme Court, and then it becomes almost a race to replace them during that president's administration. That way they can have a judge on that is kind of aligned with their viewpoints on the Constitution. Meanwhile, if we had term limits, we could better prepare for the replacement of a judge and in cases like that.
Would term limits remove the political questions that surround such appointments? You're trying to look for a neutral principle, and I'm not so sure that it's neutral. Can you help me out understand that?
I would argue that it definitely would not eliminate the political nature surrounding the appointments of Supreme Court judges. If anything, I think it would just shift it to kind of a different ideal, because on one hand, right now we have it where the current president would appoint a possible Supreme Court justice.
Time.
Can I finish my thought? Sorry.
Of course.
Please.
So they would appoint a Supreme Court justice who they would believe really interprets the Constitution probably in a similar manner to them, and then that would have to be approved. But if there were elections, then it would almost be, they would need the supportment of political parties, and then during their term, if they wanted to be reelected, they would always be focused on what that political party wanted and what the people who voted them in wanted and support them. So I don't think that it eliminates the political nature of it. I think it just shifts it to a different manner.
Okay. Look, thanks, folks. My colleague is applauding, so you must have done just fine, and you did do just fine. Look, these are tough, complicated ideas. Judicial review, the question of federalism, counter-majoritarianism. Literally, these are some of the issues that state representatives, federal representatives, the federal bar, the Supreme Court struggles with. And now we've asked you guys to struggle with them as well. So you've actually done a nice job of trying to get your head around some of these issues. For example, with my question on court-created doctrines, I thought you were going for like doctrines like the political question doctrine that the court can use not to take cases, for example, or the incorporation doctrine to bring the Federal Bill of Rights against the states and against individuals within states through the Due Process Clause of the 14th Amendment. That's all I was trying to go for there. So I thought, and then my other issue was, you kind of danced around it, and although I think you explained it, was the problem of majority tyranny and the question of majority tyranny, yet minority rights matter as well. So I thought this was a hard question. I thought you did a nice job on it. Well done, folks.
I thought you all, especially in your opening, had a you were very calm. Your pacing was very good. You didn't seem rushed to get to the end. You really did a nice job in terms of laying out what was a very complex issue. I got a little confused in terms of when we were talking about term limits and other things. You kind of rushed to election of judges, which I didn't think we were. I know I was not really asking about. So I was a little confused why you began to move in that direction very quickly. I thought you might have had some deeper answers if you had maybe assumed the appointment process. And I think y'all were in slightly different places on that issue. I like the fact you didn't agree, though. That was because these are complex issues.
You're the first group that answered my question about Senator Ted Cruz's book, and one of you has read some of it. So I was very grateful. You nailed it. You knew exactly what we were asking, and that if you change from an exceedingly well thought and liberal judge to someone who is maybe less experienced and far more conservative, you get a completely different outcome. I think you also have to that follow on with that if you change the majority, if you change a 5-4 to a 4-5, if you change a 5-4 to a 6-3, and that is, let's face it, folks, they're appointed and they are politically appointed. It changes the tenor of the outlook of the whole court. You don't intend to, and you hope they will look at each case separately. But I think you nailed it, that you understood that if you change one justice, it can change a vote, a complete vote, and things can go to a different direction. I also liked that you weren't afraid to go back and talk about, Article 3 and talk about the way we translate the federal power, and if the states if they think the state is not enforcing the laws, that they can come back and do something else and sort of force the states to recognize the laws. I don't know if Alabama will ever learn that, but it's truly the case. We had Obergefell v. Hodges and a Supreme Court justice here in Alabama who said we don't have to pay attention to that, which is sort of frightening sometimes. But I appreciated how much you guys were prepared, as the other gentleman said, and how you worked together, and how you seemed very experienced at it, even though you're not. So thank you so much.
Yeah, good job, folks. All right, nicely done.
Thank you.
Good luck with everything.
Thank
Thank
you,
y'all.
guys.
Yeah. Keep working hard. Good luck with the day.
Thank you very much, students.
Thank you so much. Have a nice
Very